All right, welcome back. I've been MIA. It's been a busy couple weeks, so sorry about that. But I'm back. So we've got oof, we've got one today. We're going back to Idaho. We have a new filing in Scofield versus Guillard, the Idaho Tic Toc psychic, or the Tic Toc psychic being sued by the University of Idaho professor for defamation because the psychic has alleged the professor committed the University of Idaho murders. Um, for those of you who are new, I'm Joe. I'm an attorney in Utah, close to Idaho, but not quite. So, yeah, as always, let's start with the docket. So, case Scofield versus Guillard in the District Court of Idaho, Federal District Court. So, last time we were here, we had docket number 18, the memorandum decision and order. Basically, defendant's motion to set aside entry of default granted. Therefore, plaintiff's motion for entry of default and default judgment denied as moot. So, with that, the psychic, Tic Toc psychic, Ashley Guillard, was given 21 days to file an answer. Now, you may remember she filed a late answer. February 16th, but she was in default. So that answer didn't count. It was stricken. It's gone. So we have a new answer, docket number 20. And it actually is different. There changes have been made. So with that, it's a long one. So let's jump right in. And I'm starting on page 2 so as not to dox her address. It's public record, but I'm not a dickhead. So, at least not in that way. So, let's try not to dox people if we can avoid it. So, like I said, let's jump in. Defendant and counterclaim plaintiff Ashley Guillard submits the following answer: affirmative defenses and counterclaims to plaintiff Rebecca Scofield and counterclaim defendants Rebecca Scofield, Wendy J. Olson, Elijah M. Watkins, and Corey M. Carone. She's still suing the professor's attorneys, which is insane. And generally, an answer, there's not much to cover because we've discussed this before. What is an answer? Well, you go paragraph by paragraph of the complaint and you admit or deny, essentially. You can also deny parts, or basically what I'm saying is usually it's admit, deny, whatever. But this answer does some of that, but not for the whole thing. It's it's a thing. And then of course we'll get into the affirmative defenses and the counterclaims, because we're going to live in the counterclaims and affirmative defenses today. But introduction, and I'm not going to compare this back and forth with the answer, or with the complaint. So we won't always know what all of these paragraphs correspond to. You can look it up if you want. I've got a whole video outlining the complaint. So, introduction. Paragraph 1 of the introduction of the complaint contains a narrative for which no answer is required. And then she answers. In November 2022, 4 students at the University of Idaho were murdered at a home near the campus. The tragedy has garnered attention and inflicted great sorrow throughout the university, the state, and the country. To the extent that an answer is required, Ashley Guillard denies all allegations in the introduction of the complaint. Parties. Ashley Guillard partially denies the allegations in the first sentence of paragraph 1 of the parties portion of the complaint pertaining to the allegation that Rebecca Scofield is an individual. Ashley Guillard admits the allegations in the second sentence of paragraph 1 of the parties portion of the complaint. So, this is insane. I mean, I don't know how you can dispute that Professor Scofield is an individual, because I think I know what the psychic is trying to get at. I hate calling her the psychic. That feels so dirty. I think I know what Guillard is getting at. I think she's trying to claim that in this denial of her being an individual is that Professor Scofield is a public figure. But it's not individual or public figure. It's public figure or non-public figure. And then limited public figure in the middle. But yeah. So it's not public figure or individual. That dichotomy would be individual or corporation or, nonprofit or partnership or LLC or government entity. As Professor Scofield is none of those, she is an individual. And then Ashley Guillard admits the first sentence in paragraph 2, but denies the second sentence. And then jurisdiction and venue, she denies. Factual allegations, narrative, no answer required. Lacks sufficient knowledge, so that's another thing you can do. Deny, lacks knowledge. Deny, blah, blah, blah. Lots of denials, lacks knowledge. We've got the first claim for relief, defamation, and she denies the second claim for relief, which is false statements regarding relationship defamation. Now, here we are. Affirmative defenses. Affirmative defenses. This is going to be fun. They're bad. They're just bad. So, Ashley Guillard, for her affirmative defenses, states as follows. The venue is improper for this case because it impedes upon the interest of justice under 28 U.S. Code 1404. Ashley Guillard is a resident of Texas. So, that she very well may be right here, but she's doing it wrong. So, in order for a court to proceed, it has to have personal jurisdiction. It also needs subject matter jurisdiction, which it has. but it needs personal jurisdiction, meaning it has the power to yank this person, meaning the defendant, into court. And it also has to be the right venue. So she's trying to argue as an affirmative defense that this is the improper venue and that the court doesn't have personal jurisdiction over her. That's not an affirmative defense. The way to do this is to file a 12B motion. In this case, it would be 12B1 and 12B3, I believe, meaning a motion to dismiss for lack of personal jurisdiction and for improper venue. Now, you can do that before you file your answer. In fact, you probably should do that before you file your answer, or at least do it. Well, yeah, generally you're going to want to do it before the answer. Because if you don't do it before the answer, some of those you waive if they're not your first responsive pleading. So she's waived them now because they weren't her first responsive pleading, and to the extent she did it in her first responsive pleading, she did it wrong. But that's okay because we're going to see later on that she's basically assented to the court having jurisdiction because she's doing things wrong because she's pro se. Yeah. So, affirmative defense 2. The venue is improper for this case because the events giving rise to the claims of defamation are the publishing of Tic Toc videos that took place on Ashley Guillard's Tic Toc social media page. There is no federal district in which this action may otherwise be brought, except United States District Court for the Southern District of Texas, pursuant to U.S. Code 1391 and 28 U.S. Code 1404. Once again, she's doing this wrong. But in addition to that, I would argue Idaho is the right venue for this because, yes, the videos were made in Texas and posted onto TikTok. And generally, venue is going to be either where the events took place or where the defendant lives, generally. But the events giving rise to the defamation include the subject matter of the defamation. That would be the Idaho murders. So the witnesses for that are all in Idaho. Although some might be in Washington and maybe even in Pennsylvania, because that's where Koberger is from. And he was a student at Washington State University, which is right over the border from Moscow, Idaho. So most of the witnesses are right there in Idaho or just over the border. So the reality is that's the right jurisdiction for this. And then we have affirmative defense 3. The complaint fails to state a claim upon which relief can be granted. 12B6 would be that you do a 12B6 motion. But once again, you've got to do that before your first responsive pleading. So you do it before your answer, not as an affirmative defense. This 4. Plaintiff's claims are barred by the substantial truth doctrine and the incremental harm doctrine pursuant to Masson versus New Yorker magazine from the Supreme Court. No. Just no. Besides which, it's not decided if it's a substantial truth at the outset. That now you may get to the point where one side has shown so much evidence that it either is dismissed before trial or the professor is granted summary judgment before trial, but the that's not it's not an affirmative defense. The substantial truth and the incremental harm doctrine hold that if the defamatory statement does no more harm than the true statements about the plaintiff, then there is no actionable claim for defamation. Rebecca Scofield planned, ordered, and executed the murder of the 4 University of Idaho students. Since the accusations in Ashley Guillard's Tic Toc videos are substantially true, there is no actionable claim for defamation. Except the only evidence of that is Guillard's Tic Toc videos. All the other real evidence that we know of points to Brian Kohberger. The Moscow, Idaho police saying, yeah, Professor Scofield has nothing to do with this. That would kind of tip the scales in the other way. Plaintiff's claims are barred by qualified privilege. The 4 University of Idaho students were brutally murdered. Without the arrest of the murderers, there's a presumption of danger to the public, University of Idaho constituents, and Idaho residents. Discovering and revealing the murderers with the intent to get them investigated and arrested is an act to warn others about harm or danger and to bring resolution to the problem. The statements were made in the best interest of public safety. Ashley Guillard made the statements without actual malice. Therefore, qualified privilege permits Ashley Guillard to make the statements that in a different circumstance would typically be considered defamatory. One, what is this qualified privilege that she's making up? 2, they were made without actual malice. She's hinting here that one of her defenses is, well, Professor Scofield's a public figure, so it needs to be the actual malice under New York Times versus Sullivan, or other way around, Sullivan versus New York Times. And therefore, even if I'm wrong, there's no actual malice, so it doesn't matter, even though I would argue, yes, there is actual malice. But also, this imagined qualified privilege permits Ashley Guillard to make statements that in a different circumstance would typically be considered defamatory. Is this an admission that this is defamatory? Yikes. Plaintiff's claims are barred by the parameters of the broad freedom of expression guaranteed by the First Amendment of the Constitution of the United States of America. The First Amendment of the United States Constitution provides that Congress makes no law respecting an establishment of religion or prohibiting its free exercise. It protects freedom of speech, the press, assembly, and the right to petition the government for redress of grievances. Ashley Guillard, this is beyond ridiculous. Because when she brought up First Amendment, you know, the logical part of your brain says, oh, well, she's arguing that this is a free speech case, which we already know that free speech, the First Amendment doesn't protect you from defamation. But no, this is a First Amendment religion affirmative defense because she's a psychic. Ashley Guillard used her spiritual brain, intuition, spiritual practice, and investigative skills to uncover the truth regarding the murder of the 4 University of Idaho students and published her findings on her Tic Toc social media platform. Ashley Guillard is protected as a United States citizen to exercise her spiritual connection, abilities, and practices without being barred by the law pursuant to the First Amendment of the Constitution of the United States of America. Nonsense. Absolute nonsense. Yes, you do have the right to practice your religion, but Congress, and I mean, in this case, it wouldn't be Congress because defamation is a common law tort, meaning court created. And it's a state law, state common law tort, even though this is in federal state common law tort. I think I said court. Even though this is in federal court due to diversity jurisdiction. But funny enough, defamation doesn't say spiritual mediums cannot make untrue claims about someone, causing them damage and blah, blah, blah. It says people and corporations too, but you cannot make untrue claims harming people. So it's not infringing on her First Amendment right because it's a generally applicable law. It doesn't just apply to spiritual mediums or Catholics or whatever. It's generally applicable. Plaintiff's claims are barred by fraud because they're false, perjurious, frivolous, and claimed with malice to get away with unethical conduct, adultery, and murder. No. Plaintiff's claims are barred by comparative negligence. Plaintiff Rebecca Scofield committed the allegations that the defendant Ashley Guillard alleged. Plaintiff Rebecca Scofield is at least 51% at fault for being accused of the allegations. Therefore, the plaintiff Rebecca Scofield may not recover damages. So, comparative negligence is a thing. So, an example would be, let's say someone is speeding down the road in front of my house at double the speed limit. And I look right, but not left before I step out into the street and step right in front of that speeding car and get hit, and I'm severely injured. Well, they're speeding double the speed limit. So you'd think they're probably at fault, but hey, I didn't look, so that's on me. So what percentage of my injuries are because they were speeding versus I didn't look both ways? But existing as a professor at a university doesn't give some charlatan the right to make up stories about you to write fan fiction about you being a murderer. It That's not how it works. There is no comparative negligence. Plaintiff's claims are barred by illegality because they are perjurious pursuant to 18 U.S. Code 1621. Now, I'm not going to this time be looking up the codes and whatnot, because I did in the previous video for the first answer that was stricken. But I'm going to remind you that she's claiming it's perjurious due to federal law. Guillard has attempted at every turn to find whatever she's trying to claim in the federal code, a federal definition, a federal crime, a federal tort. But it just doesn't work that way. And we'll get that even more in the counterclaims. But this is a mistake that pro se plaintiffs tend to find themselves making. And then 10, plaintiffs' claims are barred by illegality because they're claimed with the intent to obstruct civil justice in the United States District Court for the District of Idaho, and with the intent to obstruct criminal justice with the Latah County Court in Moscow, Idaho. No. If it were obstructing justice in the criminal case, that would be for the prosecutors to bring. And filing a defamation case, even if you don't win, is not obstruction of justice. It's asinine. My head might fall off, shaking it so much, but yeah. Counterclaims. Counterclaim plaintiff Ashley Guillard brings forth these counterclaims against counterclaim defendant Rebecca Scofield and counterclaim defendant Wendy J. Olson and Elijah Watkins and Corey Carone, attorneys with Stoll Reeves LLP in Boise, Idaho, and allege as follows. Nature of the counterclaims. As set forth more fully below, November 2022, Ethan Chapin, Kaylee Gonsalves, Xana Kernodle, and Madison Mogan, the 4 University of Idaho students, were murdered. Using her spiritual acuity, Ashley Guillard uncovered hidden motives and hidden details of the murders. She discovered that Rebecca Scofield initiated, planned, and executed the murders, and hired men to help her plan and carry out the murders. Ashley Guillard published her findings on her Tic Toc social media webpage. To evade suspicion for the murder of the 4 students, on December 21st, 2022, Rebecca Scofield and attorneys with Stoll Reeves LLP in Boise, Idaho, filed frivolous complaint, Scofield v. Guillard, in United States District Court for the District of Idaho against Ashley Guillard. The complaint falsified the factual allegations and claims for relief to create a cause of action for defamation against Ashley Guillard. And I know I don't have to say this, but representing a plaintiff isn't a tort. This is insanity. It's insanity. After filing the complaint, Rebecca Scofield and Wendy J. Olson published false statements of fact about Ashley Guillard in multinational news media outlets to harass, degrade, humiliate, and discredit her, and to deprive her of an impartial tribunal. The false statements of fact published about Ashley Guillard portrayed her as someone who defamed esteemed Professor Scofield by falsely accusing her of murder. The truth is the statements Ashley Guillard made about Rebecca Scofield are substantially true. Now, imagine a world where saying, I didn't murder these four students, anyone who is saying I murdered those four students is making it up. Imagine a world where that's defamation. And I mean, this is particularly galling. Professor Schofield denied being the murderer in an effort to harass, degrade, humiliate, and discredit Guillard. Now, Guillard making Tic Toc videos, I don't know how many, but it's over 100 videos accusing Professor Schofield of being a mass murderer. Now, no, that's not harassing, degrading, humiliating, and discrediting. But denying it, that is. That's offensive, is what that is. Collectively, the attorneys and Professor Schofield conspired to deprive Ashley Guillard of her rights as an American citizen to free speech guaranteed by the First Amendment of the United States Constitution and of an impartial tribunal guaranteed by the 14th Amendment of the United States Constitution under the color of law. Ashley Guillard suffered damages due to the counterclaim defendant's malicious actions, thus making this counterclaim necessary. Last I checked, Professor Schofield and her attorneys are not cops, they're not sheriffs, they are not public officials in any way. Now, Attorney Olson was the U.S. Attorney for Idaho, but this isn't deprivation of rights under the color of law. And talking about it outside of court isn't denying you an impartial tribunal. Most people don't know about this nonsense. I mean, you look just recently in Idaho, the what's her name? Lori Vallow. They managed to seat a jury. Lori Vallow had a jury that, as infamous as that case was, they were able to get a jury. They had jurors who they'd heard of the case, but they didn't know any details. So Professor Schofield having a press conference saying, I'm not a murderer, this is nonsense. That doesn't deprive anyone of an impartial tribunal. This is nonsense. But apparently, it's malicious actions. Parties. Counterclaim plaintiff Ashley Guillard is an individual residing in Texas. She is an author, entrepreneur, and United States Army combat veteran. Counterclaim defendant Rebecca Scofield is a public figure residing in Idaho. She is an associate professor and chair of the history department at the University of Idaho in Moscow, Idaho. So it looks like I was right. She's making that false dichotomy. Like I said, it's public figure or not a public figure, individual or non-individual. The she's crossing streams. Professor Scofield is an individual. But let's discuss this now, though. Public figure. Now, for the purposes of this case, Professor Scofield is not a public figure. Just no way. Now, the truth of the matter is, though, Professor Scofield might qualify in a different set of circumstances as a limited public figure. Let's say that a Professor Scofield was at a history conference which contained the audience was full of history professors, and Professor Scofield is the keynote speaker. And so she's up at the microphone and she's lecturing this room full of 1,000 history professors. And someone stands up in the crowd and shouts, "Professor Scofield is a fraud. She plagiarized her dissertation off of my work, blah, blah, blah." Now, let me be clear. I'm not making any allegations here. This is just a hypothetical. Now, for the purposes of being a history professor and within the history academia, she might be a public figure for that purpose, meaning a limited public figure. But being a limited public figure of being a history professor within the history professor community, academic community, does not make you a public figure for some quack to find your picture on the school website and say, "Hey, that person's a murderer." She's not a public figure for that purpose, if she is a limited public figure at all. Now, that being said, Professor Scofield is now known by how many thousands of people outside the academic community? Because, I'm covering this and, well, I don't get a whole lot of views for this, but Emily Baker is covering this and she gets a couple 100,000 views, and Tozy is covering this and he gets lots of views. Markey is covering this, he gets lots of views. So wouldn't Guillard say, "Well, look, all these people know who she is"? You can't make someone a public figure by slandering them. You can't defame someone, make them infamous due to your defamation, and then say, "Well, they're a public figure now, so there needs to be actual malice." That's not how it works. That would be ridiculous. It would do away with the need for the actual malice standard, because if that were the case, then every defamation plaintiff would be a public figure. And we just scrap that standard. But moving on. Counterclaim defendant Wendy Olson is an attorney, former U.S. attorney for the District of Idaho, and a partner at Stoll Reeves LLP. Counterclaim defendant Watkins is a trial attorney and partner at Stoll Reeves. And counterclaim defendant Corey Carone is an attorney, former deputy attorney general for the state of Idaho, and associate of Stoll Reeves LLP. Jurisdiction and venue. Now, remember how earlier she argued as an affirmative defense, so she used the wrong process to argue it in the first place, but she argued, this court does not have jurisdiction over me, and this is the improper venue. She waived those arguments anyway, right here, because jurisdiction and venue. Jurisdiction is proper for the counter complaint pursuant to 28 U.S. Code 1331 and 1332 and 1343 and 1367. The counter complaint is a matter of federal question due to violation of federal laws. There is diversity of citizenship, and the amount in controversy exceeds $75,000. It's a matter of federal question due to violation of federal laws. That might be the most ridiculous thing yet. Because remember how I said, like many pro se plaintiffs or litigants, she tries to find a federal law for everything. So she's claiming, well, them filing the complaint against me, well, that was fraud. And fraud is a federal crime, therefore, except only very specific types of fraud are federal crimes. This isn't fraud anyway. And that's ridiculous. Venue is appropriate under 28 U.S. Code 1391 for the counterclaim because Rebecca Scofield is a resident of Idaho and the attorneys operate in Boise, Idaho under 28 U.S. Code 1391. So, you know how I said, well, with this argument, she has basically waived her earlier arguments. But you notice though, she says jurisdiction is proper for the counter complaint. Venue is proper for the counter claim. The problem with that is there is only one case. They're not going to hold one set in Texas and one set in Idaho arguing back and forth. It's all going to be in one court case. That it's asinine. I mean, if it's so asinine that my brain stopped working for a minute. If Ashley Guillard had simply answered this case and she filed her counterclaims as a separate lawsuit in Texas, Professor Scofield would simply go to Texas and say, hey, we've got this case going in Idaho. This is improper. I mean, and for those of you who have followed the delete laws lawsuits, you remember the notices of related cases that he's had to file? That's what that would be. She'd have to file a notice of related cases, and it would say, well, yeah, there's this Idaho case under the same facts. Well, then why aren't you in Idaho with these claims? factual allegations. There might be some facts in here. On November 13th, 2022, four University of Idaho students, and I'm not going to keep reading their names because, frankly, it's insulting that this charlatan is clout chasing off of their murders. So I want them to be able to rest in peace. So I'm not forgetting about them. I'm just, you know. But the four students were found brutally murdered in Moscow, Idaho. Their tragic murders were the result of a plan initiated and executed by Rebecca Scofield. To execute the plan, Rebecca Scofield hired men to help her plan and carry out the murders. She promised them financial security and a better collegiate experience at the University of Idaho in exchange. I mean, if that were the case, why did she get a Washington State University student to do it? That doesn't make sense. And it's like he's a PhD student, so in a different department, completely different area, and frankly, no shade to the University of Idaho, but I think most people would say that Washington State University is objectively better. Now, that, I can't speak for every department, 'cause, obviously some are better at each school, but in general, I'd say Washington State would be the higher ranked university, but somehow getting a Washington State University PhD student to commit the murders to give them a better collegiate experience at the University of Idaho. How, how does that make sense? Seriously, how does that make sense? Rebecca Scofield's motive for conspiring to murder the four University of Idaho students was to keep her secret affair with student Gonsalves, who was a student at the time, from being exposed. Once again, you're making outrageous claims against murder victims. You clout goblin. Stop it. Just stop it. Rebecca Scofield has pervasive power and influence due to her prominence at the University of Idaho, Moscow, Idaho, and surrounding areas. Her PhD from Harvard University and extreme level of ambition, as exhibited by her extensive 12-page resume on the University of Idaho's website, and her website, RebeccaScofield.com, details some of the work she's done as a public figure and leader in Moscow, Idaho. Footnote 1. A link to her university profile page. Now, this is also ridiculous. For the starts, how dare a woman be ambitious? I mean, doesn't she know her place? Now, of course, I'm being sarcastic there. I mean, she's highly accomplished in her field, and I'm glad for it. uh, once again, speechless. But 12-page resume. Academics, I'm sure many of you have heard the phrase publish or perish. In order to move up, Professor Scofield, if I remember right, is an associate professor. She's not a full professor yet, so she doesn't have tenure yet. She needs to keep publishing so as not to perish. And though all of those publications, all of the we talked about in our hypothetical, Professor Scofield speaking at an academic conference, all of those go on her resume. She's got to sell herself to the university, to her students, to book publishers, to whatever. This 12-page resume is an essential part of academia. And once again, it may indicate her position as a limited public figure in the very small academic world of history, academia, and professors. Nothing else. Rebecca Scofield valued her career and prominence at the University of Idaho, Moscow, Idaho, and surrounding areas. She was also married. How dare she? Kaylee was a popular student at the University of Idaho and Moscow, Idaho area. Her popularity grew as her success grew. Before her untimely death, her new career and Range Rover added to her popularity. Still offensive. Professor Scofield feared that the attention Kaylee got would cause their inappropriate relationship to be exposed. She feared she would lose the prominence she earned, the career that she built, and the future she was creating. That here led her to have Kaylee killed. Kaylee and Professor Scofield met at the University of Idaho when Kaylee sought mentorship for personal and professional growth. During that time, they developed a personal relationship. Guillard is trying to appeal to the court with gay panic, and that's just disgusting. Professor Scofield desired to be with a woman, but never explored that desire for fear of ridicule. Professor Scofield convinced Kaylee to experiment by being in a secret same-sex relationship with her. She's writing scandalous fan fiction about a murder victim. Just the rage. Professor Scofield convinced Kaylee to keep their same-sex relationship a secret due to fear of ridicule for dating a student. Only close friends of Kaylee had knowledge of the relationship. Professor Scofield documented the same-sex relationship experience in her book, previously titled The Experience. Her previous publications were about other people's experience with being gay. The experience was about her own. The experience lasted for at least a year. Kaylee grew to have deep feelings for Professor Scofield. During the relationship, Professor Scofield promised Kaylee that at the end of the experiment, she would garner the courage to live her life openly as a lesbian and leave her husband. She never took that courageous step, choosing to break up and remain married instead. The relationship took a turn for the worse when Kaylee was about to graduate college and move to Texas. She was no longer convinced to be in a secret love affair with married woman Professor Scofield. She threatened to expose their love affair to Professor Scofield's husband. After they broke up, Professor Schofield began to stalk Kaylee in person and on social media to keep an eye on her and to make sure her secret affair remained a secret. Kaylee's social media content alarmed Professor Schofield. She began to have anxiety and paranoia about being outed by Kaylee or her friends. Um, 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 Professor Schofield began to develop anxiety and paranoia. Did the spirits tell you that? Just more rage. More rage. Professor Schofield decided to relieve herself of the fear, worrying, and anxiety that Kaylee was going to expose her secrets of being a lesbian, having an affair, and dating a female student. She decided killing Kaylee would silence her for good. During the planning phase of the murder conspiracy, Professor Schofield watched Kaylee in person and on social media. She decided Kaylee and her close friends were a threat to her livelihood and secrets being exposed. She added Maddie, and the students Kaylee frequented with to the list of those to kill. Professor Schofield hired help to help her plan and execute the murders. She offered financial, collegiate, and career incentives as a reward, using her prominence at the University of Idaho as a tool. Her offer was accepted. During November 2022, Kaylee visited Moscow, Idaho to visit her friends before moving to Texas. Professor Schofield and her hired help took this opportunity to execute their plan to murder Kaylee and her friends. On approximately November 13th, 2022, the students were murdered as initiated, planned, and executed by Professor Scofield. Since the year 2021, Ashley Guillard used her social media platform and books to answer questions related to a variety of unsolved murders at random. She used her intuitive abilities and spiritual acuity to get insight on unsolved cases. During the month of November 2022, a Tic Toc user asked Ashley Guillard to get insight into the murders of the four University of Idaho students. Ashley Guillard agreed. She used her spiritual acuity and investigative skills to get insight into the murders. During Ashley Guillard's spiritual research, she was intuitively led to the University of Idaho History Department. Using logic, Guillard viewed the University of Idaho History Department's webpage. History Department professors and associates were listed. Using logic, she viewed the University of Idaho History Department's webpage. Usually I use my eyes to view web pages, but Guillard used logic. I'm not sure how that was the use of logic. During the spiritual investigation, Ashley Guillard spiritually inquired into each person listed on the History Department's webpage, seeking their role in the murder of the four University of Idaho students. Nearly all the insight uncovered for each person was about their reaction to the murders, except for Professor Scofield. The insight for Professor Scofield was distinctly different from that of the other history professors and associates. The insight for Professor Scofield revealed that she was in a relationship with Kaylee, that broke up, and that she initiated the murders, planned the murders, and hired help to carry the plan out. Guillard sought more information and spiritual insight to be sure of her findings. The answers didn't change. When she was 100% sure of the message, well, that means it can't even be actual malice because, there was no reckless disregard for the truth. She was 100% sure. And then she revealed her findings on Tic Toc. She also sent the information she uncovered to the Moscow Police Department's tip line, email address tipline@ci.moscow.idaho.us. Guillard posted over 100 Tic Toc videos of her findings. Professor Scofield was informed about Guillard's social media content. Professor Scofield strategized with attorney Olson to silence Guillard to evade suspicion, obstruct justice, and to avoid criminal investigation into her role in the murders of the four University of Idaho students. On December 8th, 2022, Professor Scofield and attorney Olson asked Ashley Guillard in a demand letter to stop posting her content about Professor Scofield's connection to the murder of the four University of Idaho students, falsely claiming the information to be false. Now, that's generally what happens. Before you sue, you send a cease and desist letter saying, hey, cut this out or we'll sue. Guillard doubled down. So they sued. And I guarantee the letter didn't say, stop posting content about Professor Scofield's connection to the murder. There is no connection. Guillard published that she did not have to stop posting her content about Professor Scofield's connection to the murders because she's protected by the substantial truth doctrine and the broad parameters of the First Amendment of the United States Constitution. On December 21st, 2022, Professor Scofield, with the help of her attorneys, filed a frivolous, perjurious claim alleging that Ashley Guillard defamed her with full knowledge that the statements Ashley Guillard made about her are substantially true. Despite being frivolous, the claim sought approximately $2 million in relief. Now, she keeps saying she's protected by the substantial truth doctrine and qualified privilege and da-da-da. But the lawsuit itself, she claims, is frivolous and perjurious. And I may be getting ahead of myself here. Frivolous and perjurious. It's late. I'm tired. I was going towards defamation. I was going to say there is the litigation privilege, meaning even if it's defamation, calling Guillard a charlatan for her false claims about Professor Scofield, it's protected by litigation privilege. That's the same reason why, unfortunately, Kaylee's family isn't going to be able to sue, at least based on this. They're not going to be able to sue for Guillard defaming Kaylee because it's in litigation. It's litigation privilege. Now, there might be Tic Toc videos that give that avenue, but I'm not gonna look for it because I don't want to see her Tic Toc videos. If you want to see her Tic Toc videos, go watch Atozi or Markey, or there are a few others that have done compilations commenting on her Tic Toc videos. Professor Scofield and her attorneys filed the perjurious claims to discredit Guillard's statements about Professor Scofield's role in the murder of the 4 University of Idaho students. The claims against Guillard are in bad faith, lacking in fact, and with the intent to harass, delay, embarrass, and discredit Guillard. The claims against Guillard were filed with the intent to deprive her of the right to the freedom of speech. The claim was filed with the intent to obstruct criminal justice in the case of the murder of the 4 University of Idaho students by preventing suspicion of Professor Scofield's role in the murders. Because emailing the tip line isn't enough. You've got to make 100 Tic Toc videos to make your allegations. Because, you know, the murder blocking the TikTok, the tip line, not TikTok, blocking the tip line could be obstruction of justice. But telling you to shut the hell up, that's not obstruction of justice. The claim has numerous perjurious statements. A perjurious statement that Professor Scofield didn't participate in the murders. A perjurious statement that Professor Scofield didn't know the students. That Professor does not recall ever meeting any of the students. That Professor didn't have a romantic relationship with any of the students. That the Professor didn't order the murder of the students. That the Professor didn't hire a student to plan or carry out the murders. That Guillard made false accusations about Professor Scofield's role in the murder of the 4 students. That Ashley Guillard decided to use the community's pain for her online self-promotion. And a perjurious statement that Ashley Guillard has continued to make false statements knowing they are false. Now, I find it curious that she keeps saying, now that an arrest has been made, Brian Koberger, because the lawsuit was filed before Koberger was arrested. She doesn't say who Professor Scofield is alleged to have hired to carry out the murder, who she conspired with. You'd think a psychic would be able to tell us that. But no. Professor Scofield and her attorneys published false statements about Ashley Guillard with malice without proof, without a reasonable inquiry into the legitimacy of the claims, and without regard to the truth or falsity of the statements. Professor Scofield and Attorney Olson continued to plot to harass, delay, embarrass, and discredit Guillard by publishing several false statements about Guillard in national and multinational news media. Yahoo News quoted Wendy Olson's statement, "Ms. Guillard has continued to make false statements, knowing they are false." Wendy Olson published a statement on Fox News Digital that was subsequently quoted on other media outlets stating the statements Ashley Guillard made about Professor Scofield are false, plain and simple. Attorney Olson made a statement on Fox News Digital that was subsequently quoted on other media outlets stating, "What's even worse is that these untrue statements create safety issues for the professor and her family." They do. Falsely accusing someone of murder could cause some other crazy to go out there and cause harm to the professor or her family. That's part of what makes this so infuriating. Professor Scofield and Attorney Olson published a false statement in multinational news media that Ashley Guillard compounded the trauma that the families of the victims are experiencing. Professor Scofield and Attorney Olson published a false statement in multinational news media that Ashley Guillard re-victimized the families of the slain students. Professor Scofield and Attorney Olson published a false statement in multinational news media that Ashley Guillard had no basis to make factual statements regarding any of the events that occurred in Idaho. Professor Scofield and Attorney Olson published a false statement in multinational news media that Ashley Guillard made false statements regarding Rebecca Scofield's involvement in the murder of the 4 University of Idaho students. They made a false statement in that Ashley Guillard damaged Professor Scofield's reputation. I mean, to reasonable, sane people, she probably didn't. Like, I hold Professor Scofield in very high esteem, having only heard of her through this litigation. But there are crazies out there. Made a statement that Guillard undermined law enforcement's efforts to solve the murder of the 4 University of Idaho students. The statements were published with the purpose of defaming and embarrassing Ashley Guillard and to evade suspicion of and criminal investigation of Rebecca Scofield's role in the murder of the 4 University of Idaho students. They published and disseminated the false statements about Guillard in a press release that was disseminated multinationally. Professor Scofield and the attorneys' defamatory statements about Ashley Guillard were disseminated through media channels with multi-million viewers and readers, to include ABC, Universal News, New York Post, CBS News, Time Magazine, CNN, just a random smattering of others, the Daily Beast, the Argonaut, University of Idaho student newspaper, the Independent, True Crime Network, Law and Crime, multiple YouTube channels, Apple Podcasts, multiple TikTok pages, Twitter, Facebook user posts, Mama's Uncut, NBC New York, 6 ABC, Pedestrian TV, Perez Hilton website, Oregon Live, the AP, Sandra Rose, and me. That's right. That right there. Lawyer, Pegleg Finance YouTube channel. That's me. Me. I talked about it. I'm still talking about it. Um, remember how in the previous stricken answer, I was offended not to be mentioned and she mentioned Markey and a few others, and I had never heard of Markey before. He's delightful. Go watch him. He's a commentary channel, a young British dude, and I, Emily Baker lost her mind when he was mentioned, and so I gave him a chance. He's excellent. Go watch him. She commented on me. Oh, there's someone with that name on YouTube? Ooh, this means we're enemies, Emily Baker. Just kidding. I'm a big fan of Emily too. But since Ashley Guillard is at least aware of me, I don't know if she watches my videos or has just seen that I've made videos about her. I'm going to take a minute to address Ashley Guillard specifically. First of all, I do not give legal advice on YouTube to anyone. So everything I have said, none of it is legal advice. But I'm going to give you some human advice. This is not legal advice. This is not legal advice. This is my plea to you, human to human. Human to human. Please stop being a clout goblin. Stop being awful. Just stop. Stop. You've already doubled down. Don't triple down. Just stop. Reach out to Professor Scofield's attorneys. Now, I realize you don't have $2 million to settle this today, most likely. But reach out. They very well might settle for you agreeing to go on to these national news outlets, go on NBC News, go on CNN, go on Fox News, go on ABC, whatever, and say, I, Ashley Guillard, am a charlatan, and I made all of this up. Professor Scofield is a random person who I victimized by accusing her of being a mass murderer. I am sorry. I fully take back all of those claims. And if you do that and make an offer to do, 500 hours of community service at a domestic violence shelter or whatever, they might settle for something other than finance, for something other than money. Because money doesn't cure reputational harm. But don't triple down. Don't continue being a dick. Just stop it. Try to find some way to make it right. And since I've addressed Ashley Guillard, Professor Scofield, I highly doubt you watch this or your attorneys. And on the odd chance you've watched any of my stuff, I doubt you're watching an hour and 20 minutes in. But there are a lot of people who are on your side. I realize how expensive civil litigation is. And I realize you're not going to get your attorney's fees, let alone the damages you're seeking. But on the off chance that Ashley doesn't stop being a dick and doesn't go on NBC News and apologize, I want you to have the ability to take this all the way. So while my audience isn't very big yet, there is a huge audience between EDB and Markey and Atozi and all the others. And between all of those channels, you're looking at well over 1 million people that if you were to start a GoFundMe for your attorney's fees, this case would be funded this week. Just saying. Because I'm sure, I mean, I know I would. I'm sure Emily Baker, Atozi, I mean, he's got experience as a defendant raising legal funds. I'm sure Markey would do it too. That just, it could happen if you're interested. That being said, let's move on. Now that I'm off my soapbox. Guillard was presented in a false light. Instead of being perceived as someone who used her spiritual acuity to make a positive difference in the world and to help solve the case of the murder of the 4 University of Idaho students, she was perceived as a liar who used the tragedy for personal gain. That's my perception of you. And funny enough, it didn't take this lawsuit, it didn't take any statements from Professor Scofield to cause that. You caused that, Ashley. Your TikTok videos caused that. I mean, there's this concept of a person being defamation proof. Their reputation is so terrible that nothing you say about them could make it any worse. Therefore, nothing you say could cause them damage. So, you know, if I said Kim Jong-un murdered the University of Idaho students, it's obviously not true. But he's such a brutal mass murderer anyway, or at least state-sponsored murder, that it couldn't make his reputation any worse anyway. So he couldn't collect. But you, Ashley, making these videos, your TikTok page, that's what gave you the perception of being a liar who used tragedy for personal gain. Guillard continues to be harassed, cyberbullied, and humiliated online by thousands of social media users because of the widespread defamatory statements that the professor and attorneys published about her. Don't harass Ashley. Don't harass her. Don't cyberbully her. Don't just, this is, you know, it's a zoo. Keep your arms and legs out of the animal cages. Don't interact. But when you post 100 videos on TikTok and have open comments, you're gonna get comments. And like me talking about this, This isn't harassing. This isn't cyberbullying. This is talking about news. That people posting on their own social media, even if they say, this chick is nuts, that's not harassment or cyberbullying, or it's commentary. Guillard's integrity, spiritual practice, reputation, and livelihood was compromised by the professor and attorneys to meet their goal of evading suspicion of Professor Scofield's role in the murder of the 4 students. Guillard was deprived of a good reputation. Oh, business, clients, income, a peaceful social media presence, family, and friends due to the counterclaim defendant's frivolous claim and defamatory statements about her. Once again, do you have a right to a peaceful social media presence? Now, once again, no one should be harassing and cyberbullying her, and just none of that. But let's pretend Professor Scofield never heard about this, never sued. Based on the videos alone, she'd be getting negative comments. This is ridiculous. Guillard received death threats to her email, website, and social media channels. She received unwanted negative calls and emails. She received tens of thousands of negative comments on her social media web pages and message inboxes. Once again, don't do that. But also, Ashley, the negative comments are because of your videos, not because of the litigation, not because of Professor Scofield. It's because of your videos. It's because of you. First counterclaim for relief: defamation, 28 U.S. Code 4101. Press releases and false statements alleging that Ashley Guillard made false statements regarding Rebecca Scofield's role in the murder of the 4 University of Idaho students, knowing they are false. So I mentioned before that I did this in the first video about the first answer, but I'm not going to this time pull it up. But defamation, 28 U.S. Code 4101. Remember, that is the definition of defamation for a very specific use in the U.S. Code. It's not a cause of action. 4101 is a definition, not a cause of action. So essentially, Guillard is not bringing a valid cause of action here. It would be dismissed quickly anyway, but on its face, it's not a valid cause of action. You can't sue under a definition. Counterclaim plaintiff Guillard incorporates by reference rights defined by the Constitution, federal statutes, and an interpretive case law. Pursuant to 28 U.S. Code 4101. 1. The term defamation means any action or other proceeding for the defamation, libel, slander, or similar claim alleging that forms of speech are false, have caused damage to reputation or emotional distress, have presented any person in a false light, or have resulted in criticism, dishonor, or condemnation of any person. That's the definition for the purpose of that statute. So it's saying, for the purposes of this statute, defamation includes slander, libel, similar things, But you'll notice it doesn't say defamation is a false claim that has been published that has caused damage and blah blah blah. The actual elements of defamation. It's just a definition of what constitutes defamation for the purposes of that specific law. The professor did the murders. After the hidden details of her involvement in the murders were exposed by Guillard, Professor Scofield and attorneys published defamatory statements in multinational news media outlets about Guillard. Professor Scofield and Attorney Olson defamed Guillard as a strategy to destroy Guillard's reputation and prevent Scofield from being suspected or investigated for the murder of the 4 University of Idaho students. The defamatory statements falsely portrayed Guillard as a Tic Toc user who falsely accused Professor Scofield of the murder of the 4 University of Idaho students to use the tragedy and community's pain to gain a following. The defamatory statements falsely portrayed Guillard as a liar who selfishly makes false statements about horrific tragedies knowing they are false. The defamatory statements falsely portrayed Ashley Guillard as ruining Professor Scofield's reputation. The defamatory statements about Guillard were published to over 100 news media outlets, printed on online newspapers and television broadcasted across multiple news media channels to include Time Magazine, Good Morning America, CNN, Inside Edition, Fox News, ETV, and much more. Professor Scofield and Attorney Olson published the defamatory statements about Ashley Guillard as statements of fact, knowing they are false and without any regard to the negative impacts to her life. Professor Scofield knows the statements she published about Ashley Guillard are false because she knows that Ashley Guillard was telling the truth about her role in the murder of the 4 University of Idaho students. Attorney Olson made no reasonable inquiry to determine the truth of the matter. She intentionally defamed Guillard as a tactic to degrade, discredit, humiliate, and silence Guillard, and to prevent Professor Scofield from being suspected or investigated for the murder of the 4 University of Idaho students. Defamation to a defendant's character in the news media is not a legal remedy for alleged defamation to a plaintiff. No, the legal remedy is suing. Attorney Olson, with over 16 years of experience as a United States attorney, has the knowledge and experience to make a public statement without defaming Guillard. It's almost like the statement would be, all these statements are false, and we intend to prove they are false in the court of law. But apparently that's defamation. Attorney Olson published defamatory statements to the news media about Guillard with malice to destroy Guillard in the court of public opinion. Attorney Olson's defamatory statements about Guillard are not protected by attorney immunity. Making public defamatory statements about a defendant and spreading false information on news media about a defendant is not an attorney duty prescribed by law or that is protected by immunity or absolute privilege. Attorney Olson made those statements with malice outside the setting of litigation with the sole purpose of defaming, harassing, discrediting, and intimidating Ashley Guillard out of her right to the freedom of speech guaranteed by the First Amendment of the United States Constitution. Guillard's reputation was severely damaged across the United States, internationally, and on social media due to the defamatory statements the counterclaim defendants published about her. Guillard suffered loss of business, clients, income, and the peaceful social media presence, family and friends due to the counterclaim defendants' frivolous claim and defamatory statements about her. Guillard was harassed on social media, her website, email, and by telephonic means nearly every day. She received tens of thousands of negative comments calling her crazy, issuing death threats, wishing that she'd get arrested, and more. She received unwanted telephone calls and emails from strangers wishing her ill will. The damage to her reputation and subsequent social media harassment caused Guillard emotional distress and loss of enjoyment of life. Guillard seeks recovery of financial damages, financial relief for emotional distress, retraction of all defamatory statements, and punitive damages due to the egregiousness of the counterclaim defendant's actions. I know I keep saying this, but it continues to boggle the mind that she thinks Professor Scofield denying being a murderer is egregious harm to Guillard. It's insane. Second counterclaim for relief, defamation, 28 U.S. Code 4101, defamatory lawsuit alleging that Ashley Guillard made false statements regarding Rebecca Scofield's role in the murder of the 4 University of Idaho students, knowing they are false. Once again, definition, 4101 is a definition, and defamatory lawsuit. Suing Ashley Guillard, according to Ashley Guillard, is defamation. No. Just no. Rule 11B of the Federal Rules of Civil Procedure requires that an attorney presenting to the court a pleading, written motion, or other paper, whether by signing, filing, submitting, or later advocating it, certifies that to the best of the person's knowledge, information, and belief, formed after an inquiry, reasonable under the circumstances, 1. Is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. 2. The claims, defenses, and other legal contentions are warranted by existing law or by a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law. 3. The factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. And 4. The denials of factual contentions are warranted on the evidence or, if specifically so identified, are reasonably based on belief or a lack of information. So, Rule 11, we've discussed previously, not in this case, but it's used for sanctions during litigation, as we've seen reading Rule 11 here. So what we might run into, though, is point 2 here. Well, point 1 and 2. It is not being presented for any improper purpose, such as to harass, cause unnecessary delay, or needlessly increase the cost of litigation. Having to defend a claim that a lawsuit is defamatory, that's not lawful law. There is no such thing as a defamatory lawsuit. So, unless she's able to bring a non-frivolous argument for extending, modifying, or reversing existing law, or for establishing new law Basically, unless she has a non-frivolous argument that defamatory lawsuits need to become lawful law, Ashley Guillard herself could run into Rule 11 sanctions. Oh, and we've got 4101 defamation again. On December 21st, 2021, Professor Scofield and the attorneys violated Rule 11B of the Federal Rules of Civil Procedure in its entirety. The counterclaim defendants filed a frivolous lawsuit against Ashley Guillard. And it's amazing that they managed to do that a full year before they even filed the lawsuit. The mere existence of the claim is defamatory by nature because it violates Rule 11B1 of the Federal Rules of Civil Procedure. The claim includes factual allegations and claims for relief that were false, published with the intent to silence, harass, delay, embarrass, and discredit Ashley Guillard. The claim is defamatory by nature because it violates Rule 11B2 of the Federal Rules of Civil Procedure. The claim is frivolous and unconstitutional. Professor Scofield caused the murder of the 4 University of Idaho students by initiating their murders, planning their murders, hiring the murderer, and ensuring the execution of the murderers. There is no legal claim that allows for a person to commit murder and then sue for being accused of the murder. The claim is against the law, frivolous, perjurious, an obstruction of justice, and an attempted violation of the First Amendment of the United States Constitution. The claim is defamatory by nature because it violates Rule 11B3 of the Federal Rules of Civil Procedure. The contentions are not factual and have no evidentiary support. With an opportunity for discovery, the defendant, Ashley Guillard, will have an opportunity to gather evidentiary support for her accusations about Professor Scofield's role in the murders. To prevent the opportunity for discovery, the counterclaim defendants relentlessly sought a default judgment for approximately $2 million against Guillard. No, they sought the default judgment because I know this is difficult. You were in default. You didn't respond. Imagine that. They moved for a default judgment because you were in default for not responding. But apparently that's an 11B3 violation. The claim is defamatory by nature because it violates Rule 11B4 of the FRCP. The counterclaim defendants made false statements of fact about Professor Scofield's relationship with the students and involvement in their murders. The statements were published as facts, not belief or opinions. Professor Scofield would be the one with the facts about her relationship with the student victims. They would not be beliefs or opinions. In my opinion, I never met those students. You see how that doesn't work? The claim is defamatory by nature because it publishes false statements as statements of fact. It defames Ashley Guillard's integrity, reputation, and spiritual acuity, and falsely portrays Professor Scofield as an innocent victim. That's not defamation. The claim portrays Guillard as someone who decided to use the community's pain for her online self-promotion. That statement is false and defamatory. The truth is, Guillard used her spiritual acuity to help solve the case of the murder of the 4 University of Idaho students. Professor Scofield and her attorneys portray Guillard as someone who has continued to make false statements, knowing they are false. That statement is false and defamatory. Guillard did not make any statements about Professor Scofield that weren't substantially true. This whole thing reads like a Uno reverse card. It's no you. The claim has numerous perjurious statements. A perjurious statement that Professor Scofield didn't participate in the murders, that she didn't know the students, that she didn't recall meeting the students, that she didn't have a romantic relationship with students, that she didn't order the murders, that she didn't hire the murderer, that Ashley Guillard made false accusations about Professor Scofield's role in the murder of the 4 students. Professor Scofield and her attorneys published those false statements with malice, without proof, and without regard to the truth or falsity of the statements, to evade suspicion of Professor Scofield in the murder of the 4 University of Idaho students. As a result of the frivolous claim, Guillard is forced to fight for her rights, the right to free speech, and the right to an impartial tribunal that are inalienable to her as a United States citizen. Guillard's reputation was severely damaged across the United States, internationally, and on social media due to the defamatory and false statements spread by Professor Scofield and Attorney Olson. Guillard was harassed on social media, her website, email, and by telephonic means nearly every day. She received tens of thousands of negative comments calling her crazy, issuing death threats, wishing that she'd get arrested, and more. She received unwanted negative calls and emails from strangers wishing her ill will. Guillard suffered loss of business, clients, income, and peaceful social media presence, family and friends, due to the counterclaim defendant's frivolous claim and defamatory statements about her. The damage to her reputation and subsequent social media harassment caused Guillard emotional distress and loss of enjoyment of life. Now, when it comes to her losing business clients, to that I say, good. Psychics aren't real. If it prevents future gullible people from reaching out to her and being victimized, I say, good. Guillard seeks recovery of financial damages, financial relief for emotional distress, retraction of all defamatory statements, dismissal of the frivolous claim, and punitive damages due to the egregiousness of the counterclaim defendant's actions. Third counterclaim for relief, 42 U.S. Code 1985, obstructing justice, conspiracy to interfere with the right to due process and the freedom of speech. No. If I remember right, we went over a 1985 action last time, although it might have been in a different case, but I think we did last time. But let's just move on. The pertinent aspect of 42 U.S. Code 1985, Section 2, allows for a cause of action if 2 or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory with intent to deny any citizen the equal protection of laws. The party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. For starters, being someone's lawyer in a lawsuit is not a conspiracy. But number two, this isn't how it works. A 1985 claim is, it's a civil rights violation. It's, you violated my civil rights. And if I remember from last time, 1985 is, you violated my civil rights on the basis of my race. That's a prerequisite for a 1985 claim. It has to have been on the basis of race. How is this on the basis of race? During the month of December 2021, Professor Scofield and her attorneys conspired to deprive Guillard of her constitutional right to free speech guaranteed by the First Amendment of the United States Constitution. The counterclaim defendants conspired to deprive Guillard of the freedom of speech to speak freely about Rebecca Scofield's role in the murder of the 4 University of Idaho students to prevent the truth from being exposed. The defendants executed their conspiracy to deprive Guillard of her First Amendment right to free speech on December 21st, 2021. A full year early. Wow. They must have been really planning ahead here. Professor Scofield and the attorneys filed a frivolous, perjurious lawsuit in the United States District Court for the District of Idaho against Guillard, publishing false statements as facts to conjure up a claim of defamation. Pursuant to 28 U.S.C. 4101(1), defamation, once again, it's the definition of defamation for the purposes of U.S. Code Section 4100. Has nothing to do with this. The statements Guillard made about Professor Scofield, that she initiated, planned, implemented, and hired help to execute the murder of the 4 University of Idaho students to conceal her secret desire for women and affair with Kaylee, are substantially true. It is not lawful to deprive Guillard of the constitutional right to free speech guaranteed by the First Amendment of the United States Constitution for publishing substantially true statements. Filing perjurious claims are against the law. Pursuant to 18 U.S. Code 1622, whoever procures another to commit any perjury is guilty of subornation of perjury and shall be fined under this title or imprisoned not more than 5 years or both. Professor Scofield procured the attorneys to commit perjury and submit a frivolous claim to the United States District Court for the District of Idaho. Once again, that's not how this works. Pursuant to 18 U.S. Code 1621, whoever, having taken an oath before a competent tribunal, officer, or person in any case in which a law of the United States authorizes an oath to be administered, that he will testify, declare, depose, or certify truly, or that any written testimony, declaration, deposition, or certificate by him subscribed is true, willfully, and contrary to such oaths, states or subscribes any material matter which he does not believe to be true, or 2, in any declaration, certificate, verification, or statement under penalty of perjury as permitted under Section 1746 of Title 28 U.S. Code, willfully subscribes as true any material matter which he does not believe to be true, is guilty of perjury and shall, except as otherwise expressly provided by law, be fined under this title or imprisoned not more than 5 years or both. So that's a whole lot of words, but basically, this isn't perjury. Like, even if it's not true, because they're not under oath. The I mean, it's all in here. You put the words in here, but where are they under oath? Perjury isn't just a lie, it's under oath. But Ashley Guillard might want to be careful, because if this is all it takes for perjury, her fan fiction and you know, doubling down in court, she's well, she's going to find herself walking a really fine line. And funny enough, reading that, I think the reason I thought of 1985, I think that was actually in the I don't think it was in her original answer. I think that what's it called? The case here in Utah where the crazy guy is suing to overturn the elections. Rayland Brunson. I think he claimed a 1985 claim, which was every bit as laughable in that. I could be wrong. It might not have been in there, but I think it was. If you haven't watched that, go watch those ones. They're insane. Attorney Olson, well, all the attorneys were required by law, Rule 11 of the FRCP, to conduct a reasonable inquiry of the legitimacy of the claims before filing it with the court to avoid frivolous claims and perjury. Taking the word of an alleged murderer is not a reasonable inquiry. I mean, like, if she had been charged, like, you can't just say you're a murderer, and then when you sue me, say, well, you're an alleged murderer. You can't trust the court can't trust you. Your attorney shouldn't have been able to trust you because you're an alleged murderer because I alleged it. Yeah, I mean, this logic might work if she were alleged by, let's say, the Latah County District Attorney. If she had been charged and was an alleged murderer in criminal court, then this logic might work, but not here. Taking the word of an alleged murderer is also not a belief. It is ignorance. It is a fundamental legal principle in the United States that ignorance of the law is no defense. I'm dead. I'm dead. I'm dead. If ignorance were accepted as an excuse, any person charged with a criminal offense could claim ignorance to avoid the consequences. I'm speechless. That pause was speechlessness. I literally am speechless. Like I don't even know how to respond to this so-called logic. It defies words. The attorneys did not conduct a reasonable inquiry as required by Rule 11 of the FRCP into the truth or falsity of the statements Guillard made about Professor Scofield. They collectively accepted Professor Scofield's word as fact without investigation or reasonable inquiry. Imagine that. They took it as a fact that psychics don't reel. The attorneys were negligent and failed to exercise due diligence before submitting a frivolous claim against Guillard. The attorneys were legally required to attest to the truthfulness of the claims they collectively published under oath against Ashley Guillard. They attested to the truthfulness of their claims without regard to due diligence and collectively committed perjury with Rebecca Scofield and collectively conspired against Guillard's First and 14th Amendment rights guaranteed by the U.S. Constitution. The perjurious claims against Guillard not only defamed her and caused injury, but also impeded upon her right to an impartial tribunal guaranteed by the 14th Amendment of the United States Constitution. The tribunal, case number blah, 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 filed in U.S. District Court for the District of Idaho, is unfair by nature due to the perjurious statements that make the claim possible when presented as facts. Without the false statements, the counterclaim defendants have no cause of action against Guillard. But somehow this isn't a motion to dismiss, it's a counterclaim. It doesn't make sense. If the conspiracy against Guillard's right to free speech is successful, as the defendants intends, demonstrated by docket number 10, plaintiff's motion for default judgment against Guillard, Guillard would be deprived of the right to an impartial tribunal pursuant to the 14th Amendment of the U.S. Constitution and the right to the freedom of speech pursuant to the First Amendment of the U.S. Constitution. So if the lawsuit against Guillard is successful, Guillard would be deprived of the right to an impartial tribunal for that lawsuit. If the lawsuit is successful, if the court determines through the lawsuit that Professor Scofield was defamed, then Guillard would be deprived of the right to an impartial lawsuit. How does that work? That's not A to B, that's A to C with a squiggle in between. That I mean, my brain hurts. How? Guillard's reputation was severely damaged across the United States, internationally, and on social media due to the conspiracy to deprive her of her constitutional right to the freedom of speech and due process. The lawsuit is the due process. Guillard was harassed on social media, her website, email, and by telephonic means nearly every day. She received tens of thousands of negative comments, calling her crazy, issuing death threats, wishing that she'd get arrested, and more. She received unwanted negative calls and emails from strangers wishing her ill will. Suffered the loss of business and seeks financial damages. It's getting a little repetitive. Next we have fourth counterclaim for relief, 42 U.S. Code 1986, action for neglect to prevent, 42 U.S. Code 1985, sub 2, conspiracy to interfere with the right to due process and the freedom of speech. Pursuant to 42 U.S. Code 1986, every person who, having knowledge that any of the wrongs conspired to be done and mentioned in Section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses to do so, if such wrongful act be committed, shall be liable to the party injured or his legal representatives for all damages caused by such wrongful act, which such person by reasonable diligence could have prevented, and such damages may be recovered in an action on the case, and any number of persons guilty of such wrongful neglect or refusal may be joined as defendants in the action. Well, we've already discussed why Section 1985 doesn't apply. So 1986 doesn't apply either. The defendants conspired to prevent Guillard of the right of free speech and the right to due process, as explained in all prior paragraphs of this counterclaim. At any time before the commission of the conspiracy to deprive Guillard of the right to free speech and an impartial tribunal, the attorneys could have prevented the perjurious claims from being filed. They were legally required by Rule 11 of FRCP to conduct a reasonable inquiry into the allegations that Ashley Guillard made false statements about Professor Scofield's role. Hang on. Sorry, talking too long. My throat got a tickle. They were legally required to conduct a reasonable inquiry into the allegations that Ashley Guillard made false statements about Professor Scofield's role in the murder of the 4 University of Idaho students, knowing they were false before filing a legal claim under oath. Once again, short of her psychic powers, short of clairvoyance, how does she know the due diligence that the attorneys did conduct? A reasonable inquiry would have revealed the fact that the statements Guillard made were not false, or at the very least were not proven to be false. If they were proven to be false, then they the standard is proven false. That's what the lawsuit is for. If, like, does she think you can't even bring a lawsuit if they're not proven false first? Is she serious? The counterclaim defendants used Professor Scofield's alibi that she was not in Moscow, Idaho when the 4 University of Idaho students were being murdered, and that she was driving home from Portland, Oregon after law enforcement officers discovered the murders. With over 40 years of collective experience practicing law, that's the whole sentence. With over 40 years of collective experience practicing law. That's the whole sentence. Next sentence. It is reasonable to believe that the attorneys know that Rebecca Scofield did not have to be in Moscow, Idaho for someone that she hired to carry out the murder of the 4 students. The alibi is also incomplete with key information missing, like the date and time Scofield booked the hotel, the date and time she checked into the hotel, how and when she traveled to Oregon, and who she was with. The attorneys either intentionally or negligently published an irrelevant alibi. Altogether, they did not abide by Rule 11 of the FRCP. We read Rule 11. It didn't have a requirement for completeness. In fact, I don't know if we've discussed it on this case or not, but we certainly have on the delete laws lawsuits. Rule 8. What's required in a complaint for it to survive a motion to dismiss? The Iqbal and Twombly standards. You don't have to include everything. You don't have to include all of your evidence in the complaint. You just have to include enough that if they're taken as true, which they have to be at this stage, if they're taken as true, there's enough to, on its face, say, yeah, this could be defamation. It doesn't say you've got to bring every single detail in your complaint. Otherwise, it's a Rule 11 violation and bye-bye lawsuit, but hello counterclaim. That's not how it works. Being psychic and receiving information by intuitive means does not equate to falsity. But stating false information does. A reasonable inquiry in the form of a Google search would have revealed the fact that psychics have been used in police investigations, as published by the United States Department of Justice. Footnote 2. Just a link. Pursuant to the United States Department of Justice, psychics include clairvoyants, prophesizers, telepaths, palmists, numerologists, graphologists, and metaphysicians. Both psychics and detectives base their work on intuition and, to some extent, Dorothy Allison of Nutley, New Jersey, a known psychic. It's fitting that she lives in Nutley, Nutville, has assisted police in more than 4,000 investigations and has received many letters from law enforcement agencies describing how she helped them using only the victim's date, place of birth, and location last seen. Footnote 3, which is also a URL. The article was written 30 years ago. Ergo, psychics have been used in police work for decades. The counterclaim defendant's belief or religious connotations about psychic abilities are irrelevant. A reasonable inquiry reveals that the history of the usefulness of psychics goes beyond their religion or beliefs and has been used in police work for decades. It's not being used in police work here. The Idaho police, I haven't seen them call for psychic help. It's almost like they were doing real police work. And yeah, psychics have assisted in police work. I say assisted very loosely. They've inserted themselves, or if police ever ask psychics, number one, any help is a coincidence. But number two, it's desperation on the part of the police. Clearly, the Idaho police weren't desperate. They didn't seek psychics. They found a suspect. And and let's talk psychics for a minute. You know, like I said, I don't believe it. I anything like any psychic help that has helped police in the past, I fully believe is either complete BS or a coincidence. As an example, this isn't police work, but so in high school, I was walking down the hall at lunchtime towards my car, and the hallway's mostly empty. I parked at a parking lot that most of the school didn't. So I'm walking down the hallway, and I start singing Black Dog by Led Zeppelin. I get to my car, I turn it on, and Black Dog starts. And that something similar has happened several times. I'll be humming a song, I'll turn on the radio, and the song is on. And I should specify Black Dog in that particular instance, it was the radio, not a CD. So does that make me psychic? No. Does it mean that the radio waves somehow, my head was picking them up, and because I listened to K Bear 101, the local rock station, somehow I listen to it in the car all the time, therefore my brain is tuned into it, so I picked up the radio waves. That's more likely than being a psychic, but no, it was a coincidence. It was disingenuous for the counterclaim defendants to act as if they don't know how a psychic receives information. It's disingenuous for them to think you're full of it. No. No. A reasonable inquiry in the form of a basic search engine inquiry reveals the definition of psychic intuition, tarot cards, and its multi-century history. A reasonable inquiry into the basic definition of a psychic negates the statement that Ashley Guillard has never been to Idaho and has no basis to make truthful statements about the events that occurred there. It is basic information that psychics do not have to be at a place or event to receive truthful information about said place or event. So we're doing astral projection now, are we? I'm sure Professor Scofield and her attorneys are both aware of exactly what psychics are. And they don't believe that you're psychic. Yeah, I mean, this will be really fun if it goes to trial. You know that scene in Star Wars Episode 1, The Phantom Menace, where they're testing young Anakin, and Mace Windu has the projector facing himself that has pictures coming up on it, and uh, he's testing Anakin, and Anakin's able to say, "That's a speeder, that's a whatever." Ashley Guillard is going to be embarrassed on the stand when she's proven to be a fraud. And it'll be glorious. It was disingenuous for the counterclaim defendants to allege that Guillard should believe a random comment from a social media user over her own mental and spiritual faculties. It was disingenuous for them to allege that Guillard should believe alleged murderer Rebecca Scofield, whom had not yet been properly investigated or caught, over her own mental and spiritual faculties. A reasonable inquiry in the form of asking Guillard by email or phone call would have revealed the fact that the statements Guillard made were not made with malice or ill intent. Calling someone a murderer sounds like defamation, though. And once again, you don't have to have ill intent. That like malice, if she were a public figure, which she's not, would be actual malice would be a requirement. But even though outside of the legal world, you might call malice and ill intent synonyms, in this case, they're not. And ill intent is completely irrelevant. An email or phone call to Guillard would have revealed the fact that Guillard believed the statements she published about Professor Scofield. Additionally, if the counterclaim defendants watched the videos that Guillard posted regarding Professor Scofield's role and reason for initiating, planning, and executing the murder of the 4 University of Idaho students, it would be apparent that Guillard believes everything she posted. None of the counterclaim defendants made any attempts to call or email Guillard to inquire into the reason for the allegations she made about Professor Scofield. They only made demands for Guillard to cease her freedom of speech to prevent Professor Scofield from being properly investigated. Imagine that. Well, yeah, I was defaming them, but they could have called to ask me why I was defaming her, but they just asked me to stop defaming her instead of asking me why I was defaming her. Each counterclaim defendant had the wherewithal to cease the action from being filed and to prevent the perjurious statements about Ashley Guillard from being made. None of them conducted bare minimum due diligence. None of them prevented the perjurious claims from being made. All of them conspired to deprive Guillard of the right to free speech, equal protection of the laws, and the right to fair judicial proceedings, which includes protection from frivolous claims. Professor Scofield initiated, planned, and hired men to murder the 4 University of Idaho students. To have a legal claim against Ashley Guillard, she had to lie about her involvement. Otherwise, she would have no cause of action. A claim that is only lawfully allowed due to the perjurious statements impedes upon judicial fairness. Yet, The counterclaim defendants negligently filed the claim without due care or regard to judicial fairness for Ashley Guillard. The mere acceptance and existence of the legal claims against Guillard is already a deprivation of her right to due process, which includes an impartial tribunal. Due process is a violation of her due process. She's dividing by zero here. She's dividing by zero. As my calculus professor as an undergrad said, you divide by zero, the world explodes. You can't divide by zero. She's dividing by zero. My calculus professor also, he never shot projectiles. He always shot Gary the gerbil. The right to an impartial tribunal is guaranteed by Section 1 of the 14th Amendment of the United States Constitution. It requires that no state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. A fair and just proceeding in this case would be a prompt dismissal or rejection of the claims made against Ashley Guillard due to no cause of action. Once again, though, that's for a motion to dismiss. It's not a counterclaim. The unlawful, careless, and negligent actions of the counterclaim defendants impeded upon the right of Guillard to be treated just and fair. The perjurious statements the counterclaim defendants filed prevented the court from rejecting the claims made against Guillard. Guillard's reputation was severely damaged across the United States, internationally, and on social media due to the conspiracy to deprive her of her constitutional right to freedom of speech and due process. Guillard was harassed. Guillard suffered a loss of business and income, and she seeks financial damages. Fifth counterclaim for relief, 42 U.S. Code, Section 1983, civil action for deprivation of rights, deprivation of the right to due process that's guaranteed by the 14th Amendment of the U.S. Constitution. So it's a 1983 claim, is it? 1983 is deprivation of rights under the color of law. Your civil rights aren't being violated. And even if the professor for these purposes is not a government actor. Gah. The pertinent aspect of 42 USC 1983 requires that every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory, subjects or causes to be subjected any citizen of the United States to deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress. The right to an impartial tribunal is guaranteed by Section 1 of the 14th Amendment. That was in the last section as well. The counterclaim defendants committed perjury to conjure up defamation claims against Guillard. They then filed the frivolous claim against her in the courts. The frivolous complaints the counterclaim defendants filed against Guillard were initiated with malicious intent to use and abuse the formal complaint process to deprive Ashley Guillard of the right to free speech and the right to due process. Factual allegations in a legal document are taken as fact. Oh. The claim was not rejected by the United States District Court in the District of Idaho due to the perjurious statements filed and published by the counterclaim defendants. Due to the frivolous, perjurious claims against her, Guillard is forced to defend her right to free speech to prevent its deprivation. Due to the frivolous, perjurious claims against her, Guillard is forced to participate in legal proceedings that are in bad faith and illegal. Guillard was deprived of equal protection of the laws and an impartial tribunal because the counterclaim defendants' perjured legal claims against her were taken as fact and accepted. Had the counterclaim defendants not made false statements in the factual allegations and legal claims against Guillard, there would be no cause of action and no legal claims against her. Oh. The counterclaim defendants caused Guillard to be subjected to the deprivation of her right to free speech guaranteed to her by the First Amendment of the Constitution. The counterclaim defendants caused Guillard to be deprived of her right to an impartial tribunal because without the perjurious claims, the lawsuit wouldn't exist due to no cause of action. Guillard suffered extreme emotional distress due to the added responsibilities the frivolous claim caused her. You know what causes extreme emotional distress? Having someone make 100 Tic Toc videos about you calling you a murderer, a mass murderer, and then having to go to court to try to get that charlatan to stop. Of course, Professor Scofield hired attorneys to do that for her so that she wouldn't have to experience that specific emotional distress. But, you know, being sued isn't grounds for an emotional distress IIED lawsuit. And if it like if the added responsibilities of the frivolous claim caused her extreme emotional distress and like if that were like hire an attorney. Yeah, it's expensive, but that you know you're experience the superpower benefits of being a pro se litigant in that you're being held to a lighter standard, an easier standard, and it's only costing you time instead of, you know, this has probably cost Professor Scofield $50,000 already in attorney's fees. So by not settling, by not figuring out a way to make it right, by not going to the media saying, I'm a charlatan, I made this up, please forgive me, Professor Scofield. Instead of doing that, you're tripling down and it's costing more tens of thousands of dollars before it's done. That is emotional distress. So once again, Professor Scofield, please start a GoFundMe. There are thousands of people that would love to help you. I'm serious. I mean, like, so one of my opa's closest friends, my grandfather, um, was an attorney here in Utah, uh, who my oldest cousin worked for as a basically assistant. She wasn't a paralegal. But she ran his practice. Let's be real. So 15 years ago, God, was it? It was during the Bush administration that there was a guy here in Utah named Tim DeChristopher who he made false bids in oil auctions. Basically, the federal government was auctioning off oil leases, and he was an environmentalist, and he made false bids and won because he didn't care what the bid was. He just wanted to win to, you know, be a monkey wrench and stop oil drilling here in Utah. So he was charged with federal crimes for, interfering in the auction, even though after the fact he became kind of a folk hero, and he actually was able to raise the money to pay for the auction, the winning bids. But they said, well, no, because you bid in bad faith, so even though you're trying to pay for it, we're still going to charge you. Well, so this attorney that my cousin worked for and was very close friends with my opa was one of the two attorneys representing him pro bono, or at least free to Mr. DeChristopher. One of my cousin's duties was opening the mail, and they got tens of thousands, if not hundreds of thousands of dollars in donations. This was pre GoFundMe. And it was my cousin's job to write a thank you card or a thank you email for every $5 donation. So, you know, Tim DeChristopher had his legal defense funded. Professor Scofield, you can do the same. And GoFundMe is a way easier than getting $5 checks in the mail, and not all of them were $5 checks, but just it's a lot easier getting a $5 GoFundMe than a $5 check, and the administrative costs of that. So once again, do a GoFundMe, Professor. There's a lot of people that want to help you. And Ashley, don't do a GoFundMe. There's a lot of people that want you to, well, stop. Okay, there I am, 157. Those tangents kind of take me out of my flow. Guillard suffered extreme emotional distress due to the backlash from social media users, family, friends, associates, and strangers that believed the false allegations made about her in the frivolous claim in the lawsuit. Wait, so her family and friends don't believe she's a psychic? Imagine that. Guillard's reputation was severely damaged across the United States, internationally, and on social media. She was harassed on social media. She suffered loss of business clients' income, and she wants financial recovery. Sixth counterclaim for relief: malicious prosecution, frivolous claim. Uh, a frivolous claim, or a claim is frivolous when the claim lacks any arguable basis, either in law or in fact. Knights v. Williams from the Supreme Court in 1989. It can be in the form of a lawsuit, motion, or appeal that is intended to harass, delay, or embarrass the opposition. Once again, saying, I'm not a murderer. This person published fan fiction about me being a murderer, claiming that it's true, and wouldn't stop. That is not frivolous. That's entirely reasonable. On December 21st, 2022, Professor Scofield, with the help of her attorneys, filed a frivolous claim alleging that Guillard defamed Professor Scofield with full knowledge that the statements Guillard made about her are substantially true. The counterclaim defendants perjured the factual allegations and legal claims to develop a cause of action. The claim has numerous perjurious statements. A perjurious statement that Professor Scofield didn't participate in the murder of the 4 University of Idaho students, that she didn't know the students, that she doesn't recall ever meeting the students, that she didn't have a romantic relationship with any of the students, that she didn't murder the students, that she didn't hire anyone to do the murders, that and perjurious statements that Guillard made false accusations about Professor Scofield's role in the murder of the 4 students. Professor Scofield and her attorneys published in a legal document under oath that Guillard decided to use the community's pain for her online self-promotion. That statement is false. Ashley Guillard used her spiritual acuity to get details regarding the murder of the 4 students. Professor Scofield and her attorneys published in the legal documents under oath that Guillard has continued to make false statements, knowing they are false. That allegation is frivolous. The statements Guillard published about Professor Scofield are substantially true. Professor Scofield and her attorneys published those false statements with malice, without proof, and without regard to the truth or falsity of the statements. After publishing false statements as fact under oath and filing the frivolous claim, the counterclaim defendants pushed out a multinational press release to sensationalize the defamatory frivolous complaint, but making 100 Tic Toc videos accusing Professor Scofield of murder somehow isn't sensationalized. The claims against Guillard are in bad faith, lacking in fact, and with the intent to harass, delay, embarrass, and discredit Guillard, and to retaliate against her for speaking up for the 4 University of Idaho students. I'm sure those students, if she were psychic, she'd hear them shouting, "Shut up. You're not speaking for us. Stop." The claims against Guillard were filed with the intent to obstruct criminal justice in the case of the murder of the University of Idaho students by preventing suspicion of Professor Scofield and avoiding criminal investigation into her role in the murders. The claims against Guillard were filed with the intent to deprive Guillard of her First Amendment constitutional right to the freedom of speech under the color of law. As intended by the counterclaim defendants, the frivolous claim generated multinational media attention, promulgating the false narrative that Professor Scofield is a victim of slander. The truth is, Professor Scofield is not a victim of slander. She is the initiator, planner, and executor of the murder of 4 University of Idaho students. As intended by the counterclaim defendants, Guillard was harassed and cyberbullied because of the frivolous claims the counterclaim defendants filed against her. But Guillard accusing Professor Scofield of murder, if that caused harassment and cyberbullying of the professor, which it did, that's just a natural consequence of existing as a professor at the University of Idaho. As intended by the counterclaim defendants, Guillard was humiliated, embarrassed, misrepresented, and overall defamed multinationally. As intended by counterclaim defendants, Guillard's reputation to include her spiritual acuity, integrity, character, humanitarian efforts. Seriously, humanitarian efforts and spiritual practice was ruined due to the frivolous claim filed against her being assumed as legitimate by multinational audiences. As intended by the counterclaim defendants, Guillard was frustrated due to being defamed, harassed, and forced to expend time, energy, and financial resources to fight the false claims for her inalienable constitutional rights. But Professor Scofield having to expend time, energy, and financial resources to get Guillard to stop defaming her, well, that's just, it's her fault for existing, of course. As intended by the counterclaim defendants, the frivolous claim generated multinational media attention, promulgating the false narrative that Ashley Guillard falsely accused Professor Scofield of being responsible for the murder of the 4 University of Idaho students. The truth is, Guillard used her spiritual acuity to make a positive difference in the world and to help solve the murder of the 4 students. The allegations Guillard made about Professor Scofield's motive and involvement are substantially true. Guillard's reputation was severely damaged across the United States, internationally, and on social media due to the defamation. Guillard was harassed on social media, her website, email, and by telephonic means nearly every day. She suffered loss of business, clients, income, blah, blah, blah. And she wants financial damages as her recovery. 7th counterclaim for relief: malicious prosecution, frivolous claim. Which is probably duplicative. The claim is frivolous when the claim lacks any arguable basis, either in law or in fact. Knights versus Williams, still a Supreme Court case from 1989. It can be in the form of a lawsuit, motion, or appeal that is intended to harass, delay, embarrass, impede upon justice for the opposition. Pursuant to 28 U.S. Code 1391, sections 1 through 3, a civil action may be brought in a judicial district in which any defendant resides, or a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or if there is no district in which an action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. A substantial part of the events giving rise to the false claims of defamation happened in Houston, Texas, where defendant Ashley Guillard resides. Guillard posted the videos about Professor Scofield's involvement in the murders on Tic Toc social media platform from the privacy of her home in Houston, Texas. The murder of the 4 University of Idaho students is not the cause of the civil action. Alleged defamation of character that took place online in Houston, Texas is. But once again, the murders are an essential element. In order to prove whether this is defamation or not, you've got to the primary fact is, was Professor Scofield the murderer? And the evidence for that is not on Tic Toc in Houston, Texas. It's in Idaho. If the allegations in the claim, Scofield v. Guillard case, were factual, which they are not because the entire claim is fabricated, disingenuous, perjurious, and false, the proper venue would have been United States District Court for the Southern District of Texas, where Ashley Guillard resides and where the videos were posted. Once again, no. And furthermore, this is not something like, if the court agreed with her, if the court agreed, yeah, this is the wrong venue, then it would dismiss it for improper venue or for lack of personal jurisdiction over Guillard. But once again, she has waived those because she's countersuing. So this is the appropriate venue, but it would just be dismissed without prejudice and refiled in Texas, in the Southern District of Texas. And it would be much more burdensome because all the actual witnesses, other than Guillard, are in Idaho. So it sucks for Guillard, but all the evidence is in Idaho. Filing the claim in this case in the U.S. District Court for the District of Idaho due to the tragic event of the murder of the 4 University of Idaho students occurring in Moscow, Idaho, renders the lawsuit frivolous due to the improper venue because the murder of the students is not the cause of action. But it's not frivolous. I mean, it's possible that, like, if there were no good faith argument to say, well, yeah, this is the proper venue. This is, this court does have jurisdiction. If there were no good faith argument whatsoever, and the court dismissed, and then she refiled in the Southern District of Texas, she could, as a sort of opening sanction, say, well, yeah, you can refile that here in the Southern District of Texas, but first you've got to pay the defendant's costs for getting it dismissed there in Idaho because you filed it with no good faith basis to file it in Idaho. But that's not the case here. Plus, like I said, she's already, by filing counterclaims, she's waived this argument. So, enjoy Idaho. And yes, the murder of the students is not the cause of action, but it is the majority of the facts involved in this case. The attorneys have over 40 years of experience combined experience as United States attorneys. Choosing the proper venue is rudimentary for them. Choosing the improper venue was not a matter of ignorance, but a matter of strategy. I mean, it's a matter of convenience. Because it strategically, it shouldn't matter which court it's in. The facts are the facts, and the law is the law. So you should have the same process play out, whether it's in Idaho or in Southern District of Texas. It's just a matter of convenience. And once again, if it's not a matter of ignorance, if they had no good faith basis to file it there, but that they do. The attorneys filed this case in the District of Idaho erroneously for the sole purpose of impeding upon fair judicial proceedings for Guillard by creating judicial conditions favorable for Professor Scofield and prejudice for Guillard. After filing the claims in the improper venue and demanding trial by jury, the counterclaim defendants issued a press release to penetrate the minds of the citizens of the state of Idaho and nationally with the false narrative that Guillard falsely accused Professor Scofield of murder to gain social media followers. The counterclaim defendants also used the multi-city news coverage in the state of Idaho and multinational news coverage to promulgate the false narrative that Professor Scofield didn't know the students and had nothing to do with their murders. The false allegations published about Guillard in the claims and on multinational news coverage is defamatory and perjurious. Even if the allegations were merited, hearing the case in Idaho court impedes upon judicial fairness for Ashley Guillard. To be legally qualified for jury service, an individual must reside primarily in the judicial district for 1 year, with the jury members being Idaho residents as well as Rebecca Scofield and the attorneys. It unfairly creates a camaraderie among the plaintiff, Rebecca Scofield, and the jurors. If the false narrative was presented upon a jury of Idaho residents, Guillard would be presented as an outsider Texas resident who unjustly accused their esteemed professor of the murder of the 4 University of Idaho students. No. The attorneys have enough knowledge and experience to properly interpret 28 U.S. Code 1391 to choose the proper venue. They chose to file the case in the District of Idaho in bad faith with the intent to impede upon judicial fairness for Guillard. Guillard seeks the dismissal of plaintiff's claims in Scofield versus Guillard. Guillard was harassed on social media, her website, email, blah, 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 suffered a loss of business, and seeks financial recovery of damages. 8th counterclaim for relief, 42 U.S. Code 1985, 2, obstructing justice, conspiracy to interfere with the right to due process, improper venue. It still isn't an 1985 claim. The pertinent aspect of 42 U.S. Code 1985, 2, allows for a cause of action if 2 or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory with intent to deny to any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of the laws. the party so injured or deprived may have an action for the recovery of damages occasioned by such injury or deprivation against any one or more of the conspirators. Professor Scofield and the attorneys conspired to impede upon the due course of justice in the criminal case of the murder of the 4 University of Idaho students and the civil case of Scofield versus Guillard to prevent Professor Scofield from being properly investigated and held liable for the murder of the 4 University of Idaho students. Professor Scofield and the attorneys filed a frivolous claim in the improper venue, the District of Idaho, with the intent to deny Guillard due process, which includes equal protection of the laws and an impartial tribunal. Due to the perjurious claims being taken as fact, the District Court of Idaho accepted the complaint in the case. Pursuant to 28 U.S. Code 1391, 1 through 3, a civil action may be brought in a judicial district in which any defendant resides, or a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or if there is no district in which an action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction with respect to such action. A substantial part of the events giving rise to the false claims of defamation happened in Houston, Texas, where defendant Ashley Guillard resides. Guillard posted the videos about Professor Scofield's involvement in the murders on Tic Toc social media platform from the privacy of her home in Houston, Texas. The murder of the 4 University of Idaho students is not the cause of the civil action. Alleged defamation of character that took place online in Houston, Texas is. The allegations in the claim, Scofield v. Guillard, were factual, which they are not, because the entire claim is fabricated, disingenuous, perjurious, and false. The proper venue would have been the United States District Court for the Southern District of Texas, where Guillard resides and where the videos were posted. The attorneys have over 40 years of combined experience as United States attorneys. Choosing the proper venue is rudimentary for them. Choosing the improper venue is not a matter of ignorance, but a matter of strategy. The attorneys filed the case in Idaho erroneously for the sole purpose of impeding upon fair judicial proceedings for Guillard by creating false judicial conditions favorable for Professor Scofield and prejudice for Guillard. Basically, this is the same as above. They penetrated the minds of the citizens of Idaho with a false narrative. They published claims on multinational news. Jurors have to be Idaho citizens. Therefore, they're going to be prejudiced against the outsider from Texas. They have enough experience and knowledge to interpret venue and choose the proper venue. This is new now. Ashley Guillard did not file a motion to dismiss the complaint because a motion to dismiss the complaint for improper venue prevents and prolongs Guillard from being able to file counter complaints for the illegal deformities conducted by the counterclaim defendants. Additionally, a dismissal due to improper venue does not provide Guillard with the opportunity to defend herself against the perjurious and false allegations in the complaint. She knew that the proper procedure would have been to file a 12B3 motion to dismiss for improper venue. She put in the pleadings that she knew that that's what she should have done. But she didn't because, well, I wanted my counterclaims and I wanted them now. So it was a strategy of her to just file her counterclaims instead. But that means she's stuck in Idaho. You can't have the original claims in Texas and the counterclaims in Idaho. It's one case. One case. Guillard was forced to expend time, energy, mental, and monetary resources to legally defend the false allegations in the claim in the improper venue, ergo, subjecting her to defend rights that are typically inalienable, due process, and the freedom of speech. Guillard experienced extreme mental and emotional anguish due to the egregiousness, multitude, and timing of the counterclaim defendant's behavior. The multinational news coverage defaming Guillard's character, the complaint, massive cyberbullying across Guillard's social media because of the defamatory complaint, death threats, and frivolous claims occurred simultaneously. Guillard's reputation was severely damaged across the United States, internationally, and on social media due to the conspiracy to deprive her of her constitutional right to freedom of speech and due process. Guillard was harassed on social media, her website, blah, blah, blah. She suffered loss of business, clients, income, blah, 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 and wants money. Ninth counterclaim for relief, 42 U.S. Code 1986, action for neglect to prevent 42 U.S. Code 1985, 2, conspiracy to interfere with the right to due process that's guaranteed by the 14th Amendment of the U.S. Constitution. Once again, if 1985 doesn't apply, 1986 isn't either, since it's a companion piece of legislation. Um, 42 U.S. Code 1986. Every person who, having knowledge that any of the wrongs conspired to be done and mentioned in Section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses to do so, if such wrongful act be committed, shall be liable to the party injured or his legal representatives for all damages caused by such wrongful act, which such person by reasonable diligence could have prevented, and such damages may be recovered in an action on the case, and any number of persons guilty of such wrongful neglect or refusal may be joined as defendants in the action. Professor Scofield and the attorneys filed the frivolous claim in the improper venue, Idaho, with the intent to deny Guillard due process, which includes equal protection of the laws and an impartial tribunal. The counterclaim defendants were bound by law to prevent the conspiracy to deprive Guillard of due process, an impartial tribunal, as United States citizens and U.S. attorneys for District of Idaho. Pursuant to Preamble 1 of the Idaho Rules of Professional Conduct, a lawyer, as a member of the legal profession, is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the equality of justice. Pursuant to Preamble 2 of the Idaho Rules of Professional Conduct, as negotiator, a lawyer seeks a result advantageous to the client but consistent with requirements of honest dealings with others. Pursuant to Preamble 4 of the Idaho Rules of Professional Conduct, in all professional functions, a lawyer should be competent, prompt, and diligent. Pursuant to Preamble 5 of the Idaho Rules of Professional Conduct, a lawyer's conduct should conform with the requirements of the law, both in professional service to clients and in the lawyer's business and personal affairs. A lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. A lawyer should demonstrate respect for the legal system and for those who serve it, including judges, other lawyers, and public officials. Pursuant to Preamble 9 of the Idaho Rules of Professional Conduct, it is a lawyer's obligation to preserve the integrity of the legal system's search for truth while maintaining a professional, courteous, and civil attitude toward all persons involved in the process. The attorneys violated several facets of Idaho Rules of Professional Conduct by intentionally filing the case a frivolous claim in the improper venue and by conspiring to deprive Guillard of the constitutional rights to due process to include an impartial tribunal. The attorneys were legally required to report the misconduct by Rule 8.3a of the Idaho Rules of Professional Conduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate professional authority. This is such nonsense. All the counterclaim defendants had the wherewithal to prevent the action, report the unethical conduct, and cease participation. Yet, all the counterclaim defendants failed to do so. It's almost as if all of the attorneys believe in this case. They believe that they filed a legitimate case. Imagine that. Ashley Guillard suffered damages due to the intentional wrongful neglect of the counterclaim defendants. Guillard experienced extreme mental and emotional anguish due to the egregiousness, multitude, and timing of the counterclaim defendants' behavior. The multinational news coverage defaming Guillard's character, the defamatory complaint, cyberbullying, blah, blah, blah. She was severely damaged across the United States, internationally, and on social media due to the conspiracy to deprive her of her constitutional right to the freedom of speech and due process. She was harassed on social media and by telephone, and she wants money. 10th counterclaim for relief: intentional infliction of emotional distress. Frivolous claim. So, you know how I often say, RICO, it's never RICO. RICO is the legal equivalent of lupus. Because on the TV show House, they say it's never lupus. Intentional infliction of emotional distress is RICO's cousin. It's RICO's favorite cousin. And like intentional infliction of emotional distress for a frivolous lawsuit claim, like that's even more lupus than RICO. It once again, she's dividing by zero. The tort of intentional infliction of emotional distress has 4 elements. 1, the defendant must act intentionally or recklessly. 2, the defendant's conduct must be extreme and outrageous. And 3, the conduct must be the cause, 4, of severe emotional distress, citing Hyatt. Would be nice if she included the entire citation. On the bright side, it wasn't some definition from the federal code, because once again, this intentional infliction of emotional distress is a state law claim. Well, a state common law claim, hence the elements coming from Hyatt, court case. But filing a lawsuit isn't extreme and outrageous conduct. And this wouldn't rise to the level of severe emotional distress. But, what do I know? On December 21st, 2022, Professor Scofield, with the help of her attorneys, filed a frivolous claim alleging that Guillard defamed Professor Scofield with full knowledge that the statements Guillard made about her are substantially true. The counterclaim defendants perjured the factual allegations and legal claims to develop a cause of action. Professor Scofield and her attorneys published in the legal document under oath that Guillard decided to use the community's pain for her online self-promotion by falsely accusing Professor Scofield of causing the murder of the 4 University of Idaho students. Professor Scofield and her attorneys published the legal documents under oath that Guillard has continued to make false statements, knowing they are false, to increase social media followers and to make a profit. That's what we call being a clout goblin. Professor Scofield and her attorneys published those false statements with malice, without proof, and without regard to the truth or falsity of the statements. The claim, Scofield versus Guillard case, has numerous perjurious statements. A perjurious statement that Professor Scofield didn't participate in the murder of the students, that she didn't know the students, that she doesn't recall ever meeting any of the students. And just once again, how would Guillard know what Professor Scofield recalls? Perjurious statement that Scofield didn't have a romantic relationship with students, that she didn't order the murder of the students, that she didn't hire a hitman. Several perjurious statements that Guillard made false accusations about Professor Scofield's role in the murder of the 4 students. The truth is the inverse. Professor Scofield initiated, planned, and executed the murder of the students. She also hired the murderer to carry out the murders. The defamatory statements the counterclaim defendants published in the claim were assumed as factual. As intended by the counterclaim defendants, Guillard was frustrated due to being defamed, harassed, and forced to expend time, energy, and financial resources to have to fight the false claims against her inalienable constitutional rights. As intended by the counterclaim defendants, the frivolous claim generated multinational media attention, promulgating the false narrative that Guillard falsely accused Professor Scofield of being responsible for the murders. Guillard's reputation was severely damaged across the United States, internationally, and on social media due to the defamatory and false statements in the frivolous complaint. Guillard was harassed on social media. She suffered a loss of business, and she wants money. 11th counterclaim for relief: intentional infliction of emotional distress, multinational press release, and news coverage defaming Ashley Guillard. The tort of intentional infliction of emotional distress has 4 elements. The defendant must act intentionally or recklessly, the defendant's conduct must be extreme and outrageous, and the conduct must be the cause of severe emotional distress. Those elements are still from Hyatt. On December 21st, 2022, Professor Scofield, with the help of her attorneys, filed a frivolous claim alleging that Guillard defamed Professor Scofield with full knowledge that the statements Guillard made that Professor Scofield initiated, planned, executed the murder of the students and hired the hitman are substantially true. The counterclaim defendants perjured the factual allegations and legal claims to develop a cause of action. Professor Scofield and Attorney Olson submitted a press release to multinational news outlets to sensationalize the frivolous complaint in the case and to spread the false statements about Guillard. Professor Scofield and her attorney's defamatory statements about Guillard were disseminated through media channels with multi-million viewers and readers to include ABC, Universal News, New York Post, CBS News. I'm just going to read more of the random news outlets. Daily Nation, Pakistan, ABC 7, Chicago, The Daily Beast, The Independent UK, The Wenatchee World, Sportskeeda, Mama's Uncut, Fox 5 San Diego, Techno Trends, Oregon Live, the Sports Grail website, Blavity News, and once again, me. But once again, I'm not like my reporting of this. Well, first of all, has been reporting on the lawsuit itself, on the court filings, but it's not based on Professor Scofield's statements. It's based on your Tic Tocs. You, ugh. Once again, clout goblin. I know there are other things I could say, but it's what she is. She's a charlatan. And speaking of charlatan, so I had probably a bad idea, but I'm starting a new YouTube channel, and basically I'm going to read random Wikipedia pages until I get bored. And like I want just the width and breadth of Wikipedia. So I'm going to I'll make an announcement officially, but you know, when I give the email address, I'm going to want suggestions for Wikipedia pages. Although what brought this up is I think the first one I read is going to be the Wikipedia page for charlatan, which is another good description of Ashley Guillard. The filing of the frivolous claims against Guillard and the mass disseminated press release caused Guillard extreme emotional distress, mental suffering, mental anguish, depression, shame, humiliation, shock, embarrassment, grief, anxiety, and fear. Guillard suffered a loss of enjoyment of life. Guillard typically travels on New Year's Eve, as she did New Year's Eve 2021. Instead, New Year's Eve 2022, she chose to stay inside for fear of her life, arguments, and embarrassment. Once again, does she not think any of these apply to Professor Scofield, who she falsely accused of being a mass murderer? I mean, she has the self-awareness of a rock. Guillard suffered mental anguish due to the potential harm caused by the continuous threats to kill her or hopes that she'd die. Once again, don't make death threats. Don't murder people. Don't make false accusations that someone else is a murderer. Guillard suffered mental anguish, depression, shame, humiliation, shock, embarrassment, grief, anxiety, and fear due to the false narrative about her being assumed as true by multinational audiences, causing her to stay home and isolate herself more than usual. The filing of the frivolous claims against Ashley Guillard and the mass disseminated press release influenced a massive amount of news media, social media content, articles, and videos that further disseminated the false statements, causing Guillard to be publicly ridiculed, humiliated, shamed, and threatened. The filing of the frivolous claims against Guillard and the mass disseminated press release with false statements about Guillard encouraged mass harassment against her. Guillard received harassing phone calls, emails, text messages, comments, and messages on Instagram, messages and comments on Facebook, messages and comments on TikTok, on YouTube, on her website, ashisgod.com. I mean, talk about having a god complex. Threatening to inflict harm against her, signing her up for pornography websites. Once again, don't do that. That's a dick move, no matter how awful Guillard is. Expressing wishes that she'd kill herself, maliciously misdiagnosing her as insane, maliciously misdiagnosing her as crazy, as schizophrenic, as psychosis, expressing the desire to have her arrested for the allegations about Scofield, and sending her indecent videos of body parts to include male genitals. Don't do that. Now, once again, it's not Professor Scofield causing people to misdiagnose Guillard as crazy. It's Guillard's videos. It's her. Now, and let me be clear. When I say she's crazy, I don't mean that in the clinical sense. I mean that in the colloquial sense. It's nuts. And I'm sure that's what the vast majority of the people are doing, because we are not her treating physicians, so we can't diagnose her. But yeah. The filing of the frivolous claims against Guillard and the mass disseminated press release caused harassment against Guillard by the initiation of a petition to have Guillard arrested that was signed by over 10,000 people on change.org. I mean, to my knowledge, she hasn't done anything criminal, but once again, it's her action that caused people to have such an extreme reaction to her. The filing of the frivolous claims against Guillard and the mass disseminated press release instigated harassment against Guillard. A multitude of random people sent messages to her family and friends seeking to have her committed and held in a psychiatric facility, and to get her personal address to allegedly have her arrested by Idaho law enforcement. Yeah, I mean, don't do that, but also Idaho law enforcement can't arrest people in Texas. Guillard continues to be harassed, cyberbullied, and humiliated online by thousands of social media users because of the widespread defamatory statements by Professor Scofield and her attorneys that they published and caused to be published about her. Guillard's integrity, spiritual practice, reputation, and livelihood was compromised by Professor Scofield and her attorneys. to meet their goal of evading suspicion and Professor Scofield's role Professor Scofield's role in the murder of the four students. Professor Guillard was deprived of business clients' income and peaceful social media presence, blah, blah, blah. Her reputation was severely damaged across the U.S. and internationally. She suffered a loss of business clients' income, and she wants money. Hey, that was the final cause of action. Now, her prayer for relief. Mass press release with a statement that Ashley Guillard approves to every news outlet that Scofield v. Guillard was covered, and to social media outlets Facebook, Twitter, TikTok, Instagram, Reddit, and all others that it was covered on, correcting the false claims made against Guillard. I can tell you, as one of those social media outlets, that ain't gonna happen. Like, the court can first off, the court is not going to force Professor Scofield to issue an apology or a press statement of any kind. But it's especially not going to force that laundry list of media outlets to publish that statement. That's insane. Mass press release in every news outlet that this lawsuit was covered, and to social media outlets Facebook, Twitter, TikTok, Instagram, Reddit, and all others that the case was covered on, with an apology to Guillard that she approves for all the accusations made against her. When Professor Scofield wins, is Guillard going to accept, the demand for an apology? No. Past, present, and future compensatory damages, punitive damages, financial relief for non-pecuniary damages, and financial relief for aggravated damages for each merited counterclaim. Attorney and court fees that may arise now or in the future for any action related to this case. For judgment dismissing the plaintiff's claims for improper venue pursuant to Federal Rule of Civil Procedure 12b3 and frivolousness pursuant to FRCP Rule 11 with prejudice. Not gonna happen. For an order imposing sanctions on the attorneys, pursuant to FRCP Rule 11C3. For summary judgment for the counterclaim, pre-judgment and post-judgment interest, and all such other relief as the court deems just and equitable. Request for summary judgment pursuant to FRCP Rule 56. Ashley Guillard requests a summary judgment for the counterclaim. No. I mean, for starters, she's not going to receive summary judgment. Professor Scofield could receive summary judgment dismissing most of the counterclaims, if not all of them. But Guillard won't. But even if she could, you don't ask for it now. I mean, Professor Scofield's at least got to answer the counterclaims first. And even then, you're generally going to get into discovery first. I mean, she like there is no evidence yet to like you can get a 12b6 granted, which is where they assume everything is true. It's just there is no evidence. There are disputed facts, so it's just it's ridiculous. But it signed Ashley J. Guillard, defendant slash counterclaim plaintiff. Signed May 16th, 2023, Ashley Guillard, pro se litigant. And it was served by the CM-ECF system. Oh. Yikes. That was painful. That was painful. But at this point, it's we've got ourselves a lawsuit. I feel terrible for Professor Scofield. I mean, the denial of the motion for default judgment, legally it was the right decision, but it sucks. It sucks that Professor Scofield's going to have to expend more time and money and effort and aggravation and heartache, and it's a no-win situation for her. At this point, we've got ourselves a lawsuit. It could be decided on summary judgment. It very well could go to trial. If it goes to trial, federal court, so unless the rules change between now and trial, it will not be recorded, no video, no streaming. Although there is a possibility that might change in the near future. So whether that does during the pendency of this case, I have my doubts, but we'll see. But either way, it could be a good excuse to go visit my cousins in Boise. My cousins who have a guest room, and I'm always invited. So and it's a short by Western US standards drive, 5 or 6 hours, Salt Lake to Boise. So I very well might just, if it goes to trial, drive up and sit in on it. So with that, we're approaching 3 hours and 39 minutes of me blathering on, and that's longer than I wanted, but shorter than I kind of expected with a 61-page motion. So do all the YouTubey things, like, share, subscribe, and I will see you very soon for the next one. Thanks for joining me. Bye-bye.